Whether it's duty counsel or a retained lawyer, one of the things that is of most value is negotiation. If you're going to plead guilty, if it's a first offense, you want to at least have a chance of avoiding a criminal record. This will depend on the seriousness of the offense and how much prep you and your lawyer have done before the sentencing. If you require some counseling, has that been initiated? If there's a problem with addictions, is that being addressed? Because what you want to do is ask the Crown to consider perhaps diverting you or putting you into an alternate measures type of resolution. Now this means that you would sign a contract and admit guilt, and perhaps you would do some community work service or other tasks that you may be asked, and if those tasks are successfully completed, the Crown will stay the charge, drop the charge. That's one way of avoiding a criminal record. The next is to ask the judge for a discharge. There can be a conditional discharge or an unconditional discharge. Unconditional discharges are very rare, but that's where a person is pled guilty in front of a judge and the judge feels enough is enough. I accept your guilty plea, but I'm going to discharge you. There's no criminal record. More common is a conditional discharge, where you're put on a period of probation. Again, you might have to take counseling, you may have to do some community work service, you may have other conditions as well. But if you're successful in completing the probation, then the charges are dropped and you do not have a criminal record.